This is your Senior Moment, brought to you by Senior Guide USA, with your host, Lee St. John.
Hi, this is Lee St. John, and my guest today for your Senior Moment is Mr. Eric Holk. Welcome, Eric.
Thank you, Lee.
Now, my understanding is you are a specialist in the area of estate planning.
That is correct.
So, first of all, before we get into what it is, how to choose a quality estate planner, how did you get involved with estate planning in the first place?
Well, it's an interesting question. I don't get asked that very much. I used to be a college counselor, but with state budget cuts wiping out a lot of state-funded positions like that, I opted for a second career in a related type of counseling, law. And the area of law that interested me most was the estate planning arena because it's not laden with confrontation and adversarial proceedings. It's more trying to help people think ahead and plan for the inevitable and be better prepared to help their families adjust in the event of death.
Absolutely. So how does one find a quality estate planner?
Well, in California, which is where I practice, the California State Bar has a separate standard for people who specialize in various areas. It's called what they refer to as a certified specialist. I happen to be a certified specialist through the State Bar in the area of trust, estate planning, and probate law. And if you've got any similar kind of arrangements in other states, the thing to do would be to look for somebody who does have that added designation or specialty. Barring that, it's best to look for someone who makes estate planning, trusts, wills, probate, the primary focus of their practice. This is not the kind of thing you really want to go to a generalist attorney for. You want to be able to deal with somebody who really knows their stuff in this particular area because laws tend to change with regularity, and
Yes.
You need to stay on top of that, and it's a very complex field of law.
All right, so if someone's saying, yes, but I already have a good relationship with my attorney, or I have a really good relationship with my financial planner, can't they do this for me?
Well, financial planner, legally no, because to actually do an estate plan for someone involves the preparation of legal documents, and someone who's not a licensed attorney would be running the risk of practicing law without a license.
Fantastic advice.
That becomes a problem. Unfortunately, we've had a flurry over the last few decades of people blitzing in through town with their seminars and special deals and that sort of thing, and it's almost what I would refer to as hit and run estate planning, because once they've done their work, collected their fees, they're gone, and there's no one there to take questions to, ask for advice, or even settle the estate when things are done. Better to stick with an attorney who's really specialized in this area. Having said that, though, I would like to say that I do think that the financial planners out there are very, very important in the whole estate planning process. I work regularly with a number of financial planners locally, and I feel that the clients are going to get a better collective advice from the bunch of us working together, and I would include their accountant in that team.
Yes.
All three of us should be part of the planning process with the client to give them what they really, truly need.
And now a lot of people will say, well, yes, I don't have all of that much. Do I really need an estate planner? So first of all, what do estate planners actually do, Eric?
Well, estate planning is broader than you think. A lot of people think it's nothing more than just getting a will done. Well, that's part of it, and that's certainly the foundational part. Sometimes it may be appropriate to have a living trust done, and there's a lot of reasons for doing living trusts. But then usually there's more documents involved in it to do a complete estate plan. You would have a durable power of attorney, for example, that addresses how your assets might be managed by a designated agent in the event that you're incapacitated. That's not something a will is going to help you with. So, that would be an important document as part of the estate plan. Another important document would be the Advanced Healthcare Directive, which goes by different names in different states. You might have a medical power of attorney or a medical directive or advanced directive. Those all spell out what you would want done in the event that you have no real hope of recovery from a terminal illness, but you're no longer able to tell your doctor or healthcare practitioners what you want done for you in that situation. So the advanced directive allows you to specify what your wishes are and who you're authorizing to make sure that those wishes are followed. It's a very important document.
And one of the areas that we've seen a huge rise in inquiries and looking for assistance is Alzheimer's.
Yes, absolutely. And that's an area that is affecting more and more people, it seems. The Alzheimer's Association has some wonderful resources, and anyone who's dealing with an Alzheimer family member really needs to make contact with the Alzheimer's Association and find out what resources and help they have available.
From an estate planning perspective, how is something like that handled?
Well, if someone's already got Alzheimer's, they may have waited a little bit too long to do their estate planning. We need to have somebody take care of their estate planning when they're still competent to do so. So it's not the sort of thing you want to wait until you really need it, because then it's usually too late.
But unfortunately, most people do. So if we're talking with somebody, because there are a lot of people turning to us with early stage dementia. So they're still very competent, they're still very compass, they're just having momentary lapses of memory.
And yes, and if they're seeing that change taking place in themselves, they really need to be alert to the fact that they don't have a lot of time to play around with. They need to take care of the things that are really important while they're able to do that.
Excellent. So if we have, a lot of our clients will say, if you mention estate planning to them, they'll say, well, I'm not a millionaire, I don't need that. What's your response?
Well, my response is that I think everybody needs to think ahead to what's going to happen to the things that they own when they pass away. If you die without a will or a trust or without having put something down in writing indicating what your wishes are, you are allowing the state to decide who's going to get your estate. I'm using the word state as, say, California or wherever. Estate is the word referring to what you own. The laws of intestate succession may end up giving your estate to somebody you didn't really want it to go to. And it won't give it to charities or church or friends or people who've done a lot of help for you over the years. They aren't even going to be in the list. So if you want to have some say in who's going to get what you leave behind, you have to put it in writing. You have to do an estate plan.
And that's an interesting point as well with regard to giving to charity. So on the other side of the coin,
absolutely.
If you have somebody that has significant assets, has decided that their children really can make their own way in the world, I want to give all of my millions to the Homeless Cat Society. The only way to make sure that the Homeless Cat Society gets that money, I would imagine, is to go through an estate planner who really knows their stuff.
Well, that's one way. It's possible to make donations to charity apart from direct gifts through your will or trust. And most charities do have lots of good ideas for people in terms of how they can make a gift and still get an income stream back from having made that gift. There's a lot of good things that they can do there. And that's something to explore. If a person has a charitable intent and they really want their estate to go to charity, they do need to put that in writing and do it properly.
Yeah, because I'm considering, even if it's in the will, for instance, that if it's not been done effectively by someone with your type of expertise, it's very easy to reopen to challenge.
That is an entirely possible situation, yeah. So again, and there's ways of protecting against challenges like that. There are things called no contest clauses in some states, and you know, the whole idea is that the court wants to make sure that the person who just died, that their wishes are actually going to be carried out as much as possible. That's generally the direction the law tries to take things.
Wonderful. So, Eric, to wrap us up, what would be your top suggestion for somebody who, let's say they've never even thought of estate planning, they may be in their 50s or 60s, and they say, well, I'm still fit, I'm healthy, what do I need to worry about estate planning for? What's your number one suggestion to these people?
Well, my number one suggestion is, at the very least, get a will done, so that there's something in writing stating what you want to have happen to your estate and who is going to be in charge of administering that estate. That's what we would call the executor. My preference would be to see someone not just do a will, but also have a power of attorney and a healthcare directive, because the will doesn't offer any real protections at all while you're living. It only becomes an operative document when you die. But the power of attorney and the healthcare directive are operational while the person is living, and that can make a lot of difference in terms of helping to facilitate paying bills, dealing with insurance issues, dealing with tax filings, all kinds of stuff.
That's a really, really important point, especially these days. I mean, we've got diseases popping out of the woodwork all over the place, where people are becoming incapacitated to the point that they can't look after themselves. So that medical power of attorney, for want of another phrase, to give it a broad global, no matter what state they're in, is a vital document. So, Eric,
Absolutely.
where do people find you?
Well, they can find me on the internet. If a person wanted to go to my website, which is www.trusts-etc.com. So that's trusts-etc.com. A lot of good information there, and I try to put up information that people can read and understand and not get too confused by, because this is a complicated area. And that would be my starting point.
Fantastic. Well, Eric, thank you so much for your time today.
Oh, you're very welcome. If I can make one final little
Please,
comment.
yes.
One thing that I do find that people don't pay enough attention to is beneficiary designations on things like life insurance or retirement accounts, IRAs, and so forth. Very often people don't realize the importance of designating not only a primary beneficiary, but also a secondary beneficiary, just in case the primary beneficiary doesn't survive them. I've had to probate IRAs just because there was no secondary beneficiary on the IRA itself.
Interesting.
And that costs the family a lot of extra money, and it delays the time for them to get the funds that are supposed to come to them.
And it extends the heartbreak period.
Absolutely.
No, that's a wonderful piece of advice. Well, Eric, thank you so much for your time today. This has just been totally invaluable. Thank you so much.
You're very welcome.
This is Lee St. John with your Senior Moment, brought to you by SeniorGuideUSA.com. Have a wonderful day, everyone.